My name is Samantha Barbas. I'm a professor of law at the University of Iowa College of Law. And I recently published a book called Actual Malice, Civil Rights and Freedom of the Press in New York Times versus Sullivan. And this book is a history of a landmark Supreme Court decision from 1964 called New York Times versus Sullivan. And New York Times versus Sullivan was about the First Amendment. It was a case also about libel law. And importantly, it comes out of the civil rights movement. And that's really one of the things that I wanted to highlight in my book, the way that the civil rights movement generated a lot of our modern law of the First Amendment, our law of freedom of speech and press, laws that I think are currently being contested in our cultural and political environment. But to talk a little bit about New York Times versus Sullivan, the story of New York Times versus Sullivan goes back to the mid 20th century when the civil rights movement was taking off in the South. Civil rights activists led by Martin Luther King were engaging in protests. They were engaging in sit-ins. They were conducting voter registration campaigns, engaging in an all-out attack on segregation in the South. And some Southern officials, some police commissioners, and other leaders in Alabama wanted to shut down the civil rights movement. And they also wanted to shut down the northern newspapers that were writing favorably about the civil rights movement and giving it the attention that it sought and that it needed to become a successful movement. So a police commissioner in Alabama named L.B. Sullivan sued the New York Times and some civil rights leaders, alleging that he had been defamed. He said that the Times had published some information about him that was false and that discredited his reputation, and that some civil rights leaders had also joined in on this attack. Well, this libel lawsuit was totally frivolous. The Times had not published anything that was false and defamatory of L.B. Sullivan. The civil rights leaders were innocent. L.B. Sullivan was using libel laws, which were very strict at that time, weaponizing those laws to strike back against his opponents, right? Against the activists and the newspapers that were opposing segregation. And because libel laws were so strict, L.B. Sullivan was able to prevail. He won a jury verdict of $500,000. And then a lot of other Southern officials got on the bandwagon and they realized that libel suits would be a great way to strike back against newspapers like the New York Times, the Washington Post, the Chicago Tribune, and to strike back against Martin Luther King and other civil rights activists and leaders. And this set of libel lawsuits really almost shut down the New York Times. The New York Times was facing 12 or so of these massive libel suits, which were resulting in favorable jury verdicts. And the New York Times almost was bankrupted if the Supreme Court hadn't intervened and essentially reversed L.B. Sullivan's case and instituted a more press-friendly law of libel. Newspapers like the Times could have been wiped out. And a lot of these newspapers actually stopped covering the civil rights movement because they did not want to be the victims of these frivolous libel suits, which were turning out very badly for the press. So the US Supreme Court, which had been such a protector of the civil rights movement, so this is the Warren Court, which had been responsible for landmark civil rights decisions, sees exactly what the Southern officials are doing and the way that they're weaponizing defamation suits to essentially chill the speech of the civil rights movement and these news media outlets. And because of the Warren Court's great concern for civil rights and the civil rights movement, I think it takes this case. So the New York Times appeals to the Supreme Court, and the court is receptive. Um, so the question that is presented to the Supreme Court in this case is, does the First Amendment protect speakers, defendants in libel cases, right? Does the First Amendment have anything to do with the law of libel? So prior to this time, the Supreme Court had said libel law is outside of the realm of the First Amendment. The guarantees of freedom of speech have nothing to do with speech that is defamatory. But because of the really exigent circumstances and the civil rights context, the court decides to take this case. And after some eloquent argumentation by the New York Times lawyer Herbert Wexler, who was a famous Columbia law professor, um, the court issues a very famous decision. It reverses L.B. Sullivan's libel judgment, and it institutes a rule that in a libel case involving a public official, the public official must show that the statement that is alleged to be defamatory is false and that it was made with actual malice, which means reckless disregard of the truth. So this is a very high bar to clear. It gives a lot of protection to speakers, publishers, so forth in libel cases because it requires the plaintiff to show that the speaker made the statement, false statement, knowing that it was false. And that can be very difficult to demonstrate. Indeed, in many libel cases, there may be carelessness involved, but not reckless disregard of the truth. And one thing that's really important about the New York Times versus Sullivan opinion, it's not just the rule of actual malice, which would protect the press tremendously in the coming years, but it was also that Justice Brennan, the author of the Sullivan opinion, made some really important statements about the meaning of the First Amendment. He said that the First Amendment protects a national commitment to uninhibited, robust, and wide open discourse. That is to say, that our nation's history and tradition is built around the idea of wide open discourse, wide open conversations about public issues and public officials. That's the foundation of democracy. Justice Brennan also says that the right to criticize public officials is absolutely foundational to our country and to our democracy. He said a law that would permit a critic of government or a government official to be punished without even having to demonstrate that the statement is false is completely anathema to what the First Amendment stands for. He said that libel law as it existed at that time was kind of like the old law of seditious libel going back to the 17th century, where you could actually be punished for criticizing the king or criticizing an official. And he says that's totally anathema to, again, our fundamental democratic ideals. And so Brennan's statement really became the foundation of our modern First Amendment jurisprudence. Again, the idea that the First Amendment protects speech that's critical of government, the idea that citizens have a right and a responsibility to comment on their leaders, and that the First Amendment protects wide-ranging discourse on matters of public concern. All of those ideas become the very basis of our modern First Amendment jurisprudence, which built on those ideas and amplified them. So, New York Times versus Sullivan, absolutely critical to free speech law, and it has been under attack lately. There's some who think that the court went too far, that maybe public officials and public figures should have more protection for their reputations than New York Times versus Sullivan allows. But I think that the story I tell in the book really underscores why New York Times versus Sullivan is so important. Without that decision, it would be very difficult for critics of government, critics of the status quo to speak freely without being threatened by massive libel judgments, which have a chilling effect on speech.